So you've made the decision to hire a lawyer. You've committed to it. You found someone that you feel comfortable with, and someone who hopefully understands what it is that's going on in the cases and how to possibly get you to the goal that you want to. And really, after that initial retainer decision, it feels like a real lull happens. That for most clients, they're sitting there going, well, what's going on in my case? And there's not going to be anything that's going on substantively with your case for quite some time. But there are some things that you can be doing yourself proactively to help put you in a better position. I never say to clients that you have to do these things, but I certainly would never discourage a client from taking proactive steps that might paint themselves in a better light to a prosecutor or to a judge later on. So let's talk about some of those things that you might be able to do proactively that might help in the way that the court or prosecutor view you in your case. First, a DUI school. It's very standard, but go ahead and taking care of that might be something that's of benefit to you. You don't have to do these things. It's not an admission of liability, an admission of fault, admission that you did any sort of thing wrong. But I like to let clients know that it is something that you can do. So a DUI school is where I would start. That's sort of the bare minimum. Second is a substance abuse evaluation. In the vast majority of DUI cases, even if your DUI is reduced or dismissed, you're going to have to do a substance abuse evaluation. And what is a substance abuse evaluation? It's where you go and sit down with a clinical evaluator who is licensed by the Department of Driver Services, Department of Behavioral Health, to perform an evaluation of a person to make sure that they don't have a substance abuse problem, whether or not that be drugs or alcohol, and then they'll make recommendations for treatment of that person if they do believe there's any type of issue. Usually for a person who has no prior offenses, no real substance abuse problem that is readily observable through talking with them or just looking at them, whatever it is that they're looking at, they're going to have an evaluation that recommends something like completing the DUI school. So a substance abuse evaluation, and we certainly provide a list of possible evaluators that a client can choose from in their case for them to look at and decide if they want to do that. So a substance abuse evaluation is the second thing that I typically will recommend for clients. Beyond that, a victim impact panel is a 2 or 3 hour session that's under the guidelines of the Mothers Against Drunk Driving protocol for a victim impact panel. It basically is meeting where people who have had their lives affected as a result of a drug or alcohol related incident will come in and talk about how that changed their life and what happened in the context of it and after it, what were the effects of it. So that's the third thing that I would typically tell clients to consider doing. Fourth is a little bit more tricky, and that's because community service to me is something that most clients want to begin doing. I am usually a little bit hesitant to go ahead and recommend that a client invest 40, 60, 80, 100 hours in community service because quite honestly, if you're under a court order to do it later on, I can't guarantee you that you're going to get credit for that time or that the court's going to find that time to be acceptable for your community service hours. So I'm a little bit hesitant on recommending to clients they invest that sort of time. Now, certainly if a client wants to do it, I'm more than willing to say go knock yourself out doing that, but I don't want to be in a position where later on I tell someone to begin doing community service and then a judge says, thank you so much for doing that community service, but go do an additional 40 hours now at these approved facilities. So those are the things that I believe you can do proactively whenever you're in that sort of lull period when you're like, hey, nothing's going on in my case. Well, make some things proactively happen. Do some things that might help later on in negotiating the case if you're so inclined. Now, if you're a client who says, hey, I'm never going to plead to anything in this case. I believe I'm completely not guilty. I'm not risk averse at all. I just want to go to a trial and be found not guilty. Don't do the things. And certainly if I have numerous clients who are of that view as well. And if that's what your view is, that's perfectly fine. No judgments whatsoever. But if you're in the other camp where you want to do some things that might help in negotiating the case, those are some things that you can do. My name is Ben Sessions. My phone number is 470-225-7710. Again, 470-225-7710. Thank you.